Judge,
Okay.
let me throw an interesting situation at you. So we have a good number of immigration agents or notarios out there, and some of them, well known in the Chinese community, they've been giving people the following advice. As we know, especially after COVID, getting an interview at the asylum office is really just,
Difficult.
it's difficult. We don't know when it's going to happen. And when last in, first out was introduced in 2018, you have people who apply before that, they're stuck. So we have clients who've been waiting for a very long time. So you have these agents that say, you know what, you could write a letter to USCIS and you can ask them, to, just refer your case or you withdraw your case. That's what they say. Ask to withdraw your case, okay? And when that happens, a lot of times USCIS will issue an NTA, but you ask to withdraw the case, and now the case lands in court.
Right.
That can be a problem for the 1 year because you withdrew it, didn't you?
Yeah, that was an interesting discussion we had in the office this week, where the individual withdrew their application to seek relief based upon a family-based petition through a spouse. But that marriage turned sour. And before that, the individual withdrew their asylum application because of the prospect that they were going to receive their status through marriage, family-based. But now that the marriage is sour, and the parties are contemplating divorce, the government issued a new NTA.
Oh.
And in so doing so, the big question is, can they revive their asylum application? Once they withdrew it, it's considered withdrawn, no longer pending. Yeah. And does that start the clock again for the? Does that nullify the period of time that they have had to file that, and their 1 year period has expired?
I like their chances better than the ones that the agents are having completely withdraw just for the reason of getting, gaming the system. At least there's an argument there.
Right. There is a legal argument to that one. But where the let's say the non-legal representative advised that advise you in terms of withdrawing, can you claim ineffective assistance of legal counsel? The argument there is maybe, but not probable.
And they're not counsel. Yeah,
they're not legal. They're not attorneys. They're not disciplined by the bar committee, which is one of the facets of the Lazada, that you file your complaint with them. But can you claim fraud and material misrepresentation? And therefore, it's an extraordinary circumstance. You were hoodwinked into thinking that they had that they were representing you in the same regard as an attorney would be representing you. If you believe that, there's an argument. But as I say, the probable outcome is the immigration court, and I would have ruled that that wasn't sufficient. That you need to show that it was a legal representative, someone who was admitted to the bar, that made this recommendation to you, and you accepting the advice of a layperson or somebody who holds themselves out to be an immigration expert. That becomes something that's not recognized in the Immigration Nationality Act as an exceptional circumstance.